Yeah. Are we live? Audible? Yes, so hi guys. We'll have a quick session, but an important one, purely keeping into consideration the requirements of Delhi Judicial Services examination vis-a-vis arbitration is concerned. I think the thumbnail makes it abundantly clear. This video or the live stream pertains to the important case laws, right? So the important case laws pertaining to arbitration. Now, in this video or in this live stream, what we will do is to ensure that we are well covered in arbitration case laws. Mind you, Arbitration and Conciliation Act 1996 has received a lot of interest time and again by the Supreme Court in various sections. Section 9, Section 34 being the prime focus. Of course, there are a host of other sections wherein there are a lot of important judgments. But in this session, we will cover 7 judgments delivered in 2023. Out of the 7 judgments, 6 are from the Honorable Supreme Court and 1 is from Honorable Delhi High Court. We will cover it purely keeping into consideration the requirements of the examination. We may avoid going into a lot of details. We will do so as and when and only when the case warrants. Otherwise, the summary looking into all these judgments would help immensely in your MCQs. But before we actually drag ourselves to these 7 judgments delivered in, as I said, in 2023, we will be better served before doing this exercise to perhaps look into some of the landmark cases before 2023. Now, the DJS is not focused quite a lot on case law centric questions in your MCQs. Thus far, in the recent past, by recent past I would perhaps mean if you take decade and a half, 3 case laws have been focused by DJS: ONGC versus saw pipes, second Bhatia International, third, and obviously this is also very, very important, what we call as Balco case. Because Balco naturally overruled Bhatia. Only 3 cases thus far has been probed by DJS in your prelims, of course. But we will be better served that before we actually proceed to the 2023 judgments, what we will endeavor now is to focus on some of the important judgments, including the 3 mentioned on your screen. Which are they? Number 1, Renu Sagar. Quite an interesting case. Renu Sagar Power Electric Company versus General Electric Company. This is 1987, Supreme Court. Now, of course, the very title of this case is sufficient for you to presume and conclude that this is the erstwhile Arbitration Conciliation Act, which is 1940, or rather the Arbitration Act 1940. But even in your Arbitration Act 1940, there are certain overlapping provisions which continued even in 1996, the current legislation. Host of differences, a lot of UNCITRAL model laws impact on 1996 Act, no doubt about it. But on the issue of setting aside, on the issue of what? Setting aside of arbitration award. This particular judgment, Renu Sagar Power Electric Company versus General Electric Company, is undeniably one of the most important one. Why so? Because for the first time, comprehensively, Supreme Court unequivocally held that arbitral award can be set aside in the current act under obviously section 34 if it is against public policy. And Renu Sagar came up with certain tests as to what amounts to public policy and what does not amount to public policy. And please bear one thing in mind. The tests as stipulated in Renu Sagar continued even after the enactment of Arbitration and Conciliation Act of 1996. Till when did it continue? Till the amendment, which we'll look into after some time, section 34, wherein the legislature post 2015 amendment delineated as to what amounts to or what may amount to public policy of India. Therefore, this case law is obviously a locus classicus when it comes to what amounts to public policy and under what specific circumstances arbitral award can and should be set aside. So that's our first case. And this amount of discussion on this case is much more than enough. The second case, now this is a very, very, very controversial case. I will tell you the reason of the controversy in some time, briefly though. The second case is Bhatia International versus bulk trading and others. It's a 2002 judgment, Supreme Court. Now, very interestingly, in Bhatia International, the Supreme Court dwelt into a very controversial topic. What is the controversy? I will tell you. You are aware that Arbitration and Conciliation Act of 1996 is divided into part 1 amongst other parts, part 2. Part 1 deals with what? Domestic arbitration. Part 2 deals with what? International commercial arbitration. Now, Bhatia International made a very controversial observation that section 9, which is there in part 1, wherein the court can order interim relief stroke measures, can even be extended in the case of international commercial arbitration. Now, this is very controversial. Now, why is it controversial? Let us say A company, which is an Indian company, and B company, let us say a German company, excuse me, they enter into a contract. This is international, there is an arbitration clause, so it's an international commercial agreement. Now, German company is not interested in dealing with Indian courts, let's say. As per the contract, all the disputes arising out of the agreement will be handled by London International Commercial Arbitration, which is an arbitral institution, LICA. So let us say there arose a dispute. Now B says, let us all go to LICA, which is London International Commercial Arbitration. A says, excuse me, I will not come to LICA because our parent act, which is Arbitration and Conciliation Act of 1996, has section 9, which provides power to the court to grant interim relief. B argues that, Are Baba, for that to apply, you have to constitute this agreement as a domestic arbitration agreement, but this is not a domestic arbitration agreement. This is an international commercial arbitration for God's sake. But Bhatia said, no, 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 no. Section 9, which is specifically located in part 1, which exclusively deals with domestic arbitration, can also be extended in the realm of international commercial arbitration. Therefore, the unfortunate result after Bhatia International's case was that even though a foreign party had a specific clause in that arbitration agreement, he had to subject himself to the jurisdiction of Indian courts, thereby maybe suffering order under section 9. Whatever number of heads which are available live, I'm rather interested to ask you a very important question that will again test us as to how fit you are when it comes to your arbitration. Very simple. Section 9, which provides for interim measures by the court. Can section 9 come into existence after only, let me use the word only after constitution of arbitral tribunal? It's a very important question. The question is whether section 9 can stand to be attracted only after the constitution of arbitral tribunal. That is the question. What is your answer? Those of you, I don't know whether you can chat. I presume you may. I also presume that I can see in your responses. I repeat, section 9, interim measures. Can it be ordered by the court only after the constitution of arbitral tribunal? The answer is no, sir. Section 9 can be used even before the constitution of arbitral tribunal. ये बहुत important है, याद रखना. Even before the constitution of arbitral tribunal. There is no embargo, there is no cap. Alright, so this is case number 2. Bhatia International. The first case was what? Renu Sagar. Second is Bhatia International. We have not even entered into the realm of 2023. The third case, my friends, ONGC versus Saw Pipes. This is 2003. This is what? 2003. Those of you who have joined in late, I would perhaps urge you to skip back. Yes, skip back few seconds and then observe this point which has been made on the screen, which is section 9 powers can be used under Arbitration and Conciliation Act even before the constitution of arbitral tribunal. Anyways, coming back to ONGC versus Saw Pipes. Now, it's a 2003 judgment. Again, a very interesting judgment because the court observed in this case, which is exactly what was asked in DJS, under section 34, the court can also examine the very validity of awards passed in international commercial arbitration. I repeat, in ONGC versus Saw Pipes, 2003, it was observed by the Supreme Court that under Section 34, the validity of arbitration awards, I repeat, the validity of the arbitration awards passed in ICA, matlab International Commercial Arbitration, can also come under scrutiny under Section 34. This is one of the most important observations. There are a host of other observations. We will not trouble ourselves dealing with them. The fourth case, and ladies and gentlemen, those of you who think that Arbitration and Conciliation Act, there are barely any constitutional bench judgments, unfortunately, you're hopelessly wrong. The next case law created, I would say, storm in a teacup. Storm in the teacup. Storm in a teacup. Why? Because the next case law, which is a 7-judge bench, is perhaps one of the most debated, one of the most criticized, one of the most talked about judgments in Arbitration and Conciliation Act of 1996. Sir, what is it? What is this 7-judge bench which you are again and again harping about? Very important. SBP and Co. versus Patel. Patel Engineering. Very, very, very important. SBP versus Patel Engineering. It's a 7-judge bench. Year is 2005. Now the court observed, and I want you to focus, the court observed that whenever an application under Section 11, Section 11 is what? Appointment of arbitrators. Whenever an application is made under Section 11 of Arbitration and Conciliation Act of 1996, the court is also exercising judicial powers and not merely administrative powers. Court is also exercising what? Judicial powers and not merely administrative powers when an application is made under Section 11. Loji, this created a lot of flutter. This created a lot of criticism also. Why? When the court is invested with the statutory duty of appointment of arbitrators, why in the world is it exercising judicial powers? See, the moment you exercise judicial powers, then what will you do? Then you yourself will become an arbitrator. Then you will pass final order which amounts to an arbitral award. Subsequent to this very, very controversial judgment, the Supreme Court started pleading, no. Whenever an application under Section 11 is made, the court should only look into two things. I repeat, the court should only look into two things. Number one, existence and validity of arbitration agreement. Number two, arbitrability of disputes. There are few disputes which are not arbitrable. Criminal matters are not arbitrable. Matrimonial disputes are not arbitrable. Guardianship matters are not arbitrable. Insolvency matters are not arbitrable. So, when an application under Section 11 is made, the court has only two business. Number one, as reflected on your screen, look into the existence or the validity of the arbitration agreement, and number two, look into about the arbitrability of the disputes. Nothing else, nothing more. Under Section 11. Now this is obviously against the 7-judge bench, SBP and versus Patel Engineering, because it said whenever an application comes to me, the court, either Supreme Court or the High Court under Section 11, which is appointment of arbitrators, I can use my judicial powers and not mere administrative powers. Therefore, I will look into the merits of the case also. Arey, if the court starts looking into the merits of the disputes, then why have arbitration? Therefore, a lot of confusion, a lot of unnecessary confusion happened, which eventually necessitated, I repeat, which eventually necessitated 2015 amendment, which inserted section 11(6)(a). If you have the Bail Act, and I truly hope you do, you would realize that section 11(6)(a), as it existed then, it said the courts should only look into what? Existence of arbitration agreement. The court can only look into what? Existence of arbitration agreement. Meaning, when the courts are looking into the issue of appointment of arbitrators, one more thing which the court can look into is only what? The existence of arbitration agreement. Interestingly, this section 11(6)(a) was omitted by 2019 amendment. 2019 amendment omitted what? Section 11(6)(a). But there have been host of other judgments after the 2019 omission of the section 11 subsection 6a, reverting back to the same point which I had raised earlier, that irrespective of what was held by the 7-judge bench, because the judgment of SBP stands nugatory once when 6a itself stood omitted. So that now courts have held सिर्फ दो ही चीजें देखना, existence and validity of the arbitration agreement. Number two, please, what is it? Number 2, I'm just checking whether arbitrability of the disputes. Check only these two, nothing else. So this is a small story. The fifth case, a very important one, Allen and Hamilton. Allen and Hamilton versus Home Finance. This is 2011. This is what? 2011. Now in Allen, Supreme Court dealt with the issue of arbitrability of disputes. What disputes can be made subject of arbitrations? And then very interestingly, in Allen, Supreme Court observed, we have to classify the disputes based on the rights sought for. If the right sought for is in rem, then it is not arbitrable. If the right sought for is in personam, then arbitrable. Because of the sheer impact of the judgments, or rather the award rendered by arbitral tribunal, if it starts dealing with issues which eventually gives people rights in rem, meaning right which can be exercised against the whole world, then it is way too what? Above your pay grade. Above your pay grade. Right. Now, as regards in personam is concerned, I repeat, as regards in personam is concerned, it is only a contractual dispute between two parties, and whatever the award which will be rendered by the tribunal, it will only impact party A, party B, party A, party B. So it is in personam. Therefore, the observation of the Supreme Court in Booz Allen versus Home Finance is still applicable largely even in today's times. Now, next case, very important case. But before delving into next case, I don't know whether I'm audible. I presume that I am. The reason why I've taken a pause is that I don't know as to whether you are comfortable with the concept of curial law or with words like seat venue. Very important, very important. Have you guys heard about these words? Seat venue? Seat venue. Because before going to Balco, which is Bharat Aluminium versus Kaiser Aluminium 2012 Supreme Court judgment, which overruled, I repeat, which overruled Bhatia. I don't know, I'm just asking the live chat, some of you may respond. Yes, oh, you are away, then it's fantastic. Since others have not, no, seat venue, why are you bringing in section 20 in that? No. First, you need to understand the concept. Seat refers to the law governing arbitration proceedings. I'll give you an example also. Venue is wherever the meetings happen. Ab dhyan se suno, this example will clear most of the doubts. Otherwise, I could have taken 3 hours to define this because Supreme Court has 8 important judgments to help us delineate between seat and venue. And mind you, the difference between seat and venue is quintessential. It is sine qua non for your clarity, failing which you will not be able to appreciate between domestic and international commercial arbitration. Now just look into this, how important this point is. A, an Indian company. B, a foreign company. Enter into an agreement. And as per this agreement, it will be governed by Indian Contract Act. Indian Contract Act. But, dhyan se sunna, the meetings will be held in Singapore. And it will be conducted by SICA, which is Singapore International Commercial Arbitration Center. Now, I don't have time. I'll just sum up by saying, this, my friends, reflected on your screen, wherein it states that this contract is governed by Indian Contract Act. It will be called as substantive law to the contract. Since the meetings will be held in Singapore, it will be called venue. And the entire arbitration proceedings will be held as per the rules stipulated by SICA. It will be considered as curial law. Therefore, now observe. Therefore, I'll make one very important statement or couple of important statements. Super duper important. If you understand, then it's fantastic. Then it amounts to 4 or 5 Supreme Court judgments in just 2 sentences. Dhyan se suno. Therefore, substantive law is nothing but the law governing arbitration agreement, whereas curial law is nothing but law governing arbitration proceedings. So what do you mean by law governing arbitration proceedings? कितने दिन में appoint होना चाहिए arbitrator? What should be the fees of the arbitrator? When can arbitrator issue interim measures or interim reliefs? All of that will be held by curial law. But anyways, I just want to briefly sum up. I don't have time, so obviously I will have to hop skip now to Balco, which is our sixth case. Sixth case क्या है भैया? Balco. What is Balco? Bharat Aluminium versus Kaiser Aluminium, 2012. Please note, Bharat Aluminium case, what is called as Balco case, it overruled Bhatia. Overruled Bhatia. उसके बाद क्या बोला भैया? देखो, part 1 will have no application to international commercial arbitration. Therefore, section 9, which is located in part 9, is not applicable in the case of international commercial arbitration. Chain ki saas, big sigh of relief for the foreign investors or companies which were incorporated abroad. They never wanted to be a part of Indian judicial system. They wanted the disputes to be addressed by any international commercial arbitration institution. After this particular case, it is a settled law. Of course, there are a few amendments which happened in Arbitration and Conciliation Act post Balco, specifically post 2015. Not necessary for us to delve into, and that too in a live session, because that would essentially mean that we will take each other's a lot of time, so that we cannot afford as of now. But this is a very important case which overruled Bhatia, and the observations are in front of your screen. Now, the next case law is a very interesting case law. 2020 का है. Now, it is very hard to believe that it took almost 8 to 9 case laws by the Supreme Court to understand and determine whether fraud is arbitrable. Very important case, huh? And nowadays it's in a lot of news, this case law which I'm about to quote to you. Whether fraud is what? Arbitrable. Let us say there is a contract and one of the parties allege that not only there is a breach of contract, but there was a fraud committed by the other party. Now the issue of fraud, because there is an element of criminality attached to that, which may in fact amount to criminal breach of trust, which is a punishable offense. Is fraud arbitrable? I repeat, can an arbitral tribunal pass an award in a dispute which has fraud in it? Please do not use Google now, because you will get confused, because there are so many conflicting observations by the court. But recently in 2020 case law, Vidya Drolia versus Durga Trading Corporation, 2020. In this case, very interestingly, the Supreme Court held, yes, even fraud can be arbitrable, provided there are no serious criminal allegations. Just because there is presence of fraud, in manifestly, palpably a civil dispute, that does not mean that the same cannot be subject to fraud, or rather arbitrable. That does not mean that the same cannot be subject to arbitrability. Meaning, fraud, is it arbitrable? Yes, absolutely yes, provided there are no serious criminal allegations amounting to criminal offenses in the conduct of the parties. If there are serious criminal allegations, then as Booz Allen has made it very clear, criminal disputes are not arbitrable. In rem disputes, not arbitrable, only in personam. But there are host of other Supreme Court judgments before Vidya Drolia, which was very, very clear that fraud by its very nature cannot be the subject matter of arbitration. I repeat, fraud by its very nature cannot be what? Be made the subject matter of arbitration. This is very, very important. ठीक है, ये हो गया. These are some of the most important judgments, basic judgments. Now we'll go into 2023. Yes, sir. Now we'll go into 2023. Very, very important. As I've already stated, we will deal with 7 judgments which may be the subject matter of your focus in the examination. All of them are rendered, delivered in 2023. 6 by the Supreme Court, 1 by Delhi High Court. Without wasting much of our oxygen, let us straight go to the first case. Tata Sons Private Limited versus Siva Industries and Holdings Limited. 2023 Supreme Court. Tata Sons versus Siva Industries and Holdings Limited. इसमें क्या हुआ था? Now, if you go to section 29A, it sets what? Time limit to arbitration awards. I repeat, time limit to what? Arbitration awards. Now, as regards domestic arbitration is concerned, the time limit is what? 12 months. Now, this time limit starts from what time? 12 months from the date of constitution of arbitral tribunal, 12 months from the time in which the notice of arbitration is sent, or 12 months since the first hearing of arbitral tribunal? What is the answer? 12 months from the date on which there is completion of pleadings. What of pleadings? Completion of pleadings. जैसे कि सिविल सूट में प्लेंट होता है, प्लेंटिफ फाइल करता है, यहां पे वही प्लेंटिफ क्लेमेंट बनता है एंड देन ही विल फाइल व्हाट वी कॉल ए स्टेटमेंट ऑफ क्लेम. डिफेंडेंट रिटन स्टेटमेंट करता है एंड आर्बिट्रेशन में वही रेस्पोंडेंट बन जाता है एंड वो क्या फाइल करता है? स्टेटमेंट ऑफ डिफेंस. दोनों मुकम्मल हो गया, कंप्लीशन ऑफ प्लीडिंग. नाउ इन दिस केस 2023 सुप्रीम कोर्ट जजमेंट, it said this upper limit of 12 months completion of entire arbitration proceedings in 12 months is only of persuasive value in the case of international commercial arbitration. It is absolutely binding in the case of domestic arbitration, but it only has persuasive value in the case of international commercial arbitration. This is held in 2023 Supreme Court judgment. Of course, this was in the specific context of section 29A. Now, the next case, a very, very important case, very important case. And the unfortunate part is, some of you may have pretended to have read section 34, but you have not understood section 34. The second case law, again 2023 Supreme Court judgment, very interesting and important judgment. Alpine Housing Development Corporation versus Ashok Dhariwal. Now, in this case, Supreme Court takes us to section 34 subsection 2 clause A, and then makes a very interesting observation. Before 2019 amendment, after 2019 amendment. Before 2019 amendment, ध्यान से सुनना, whenever a party aggrieved by the arbitral award, if he wants to challenge the same under section 34 for setting aside of arbitral award, then before the amendment, he was given the liberty to furnish proof. Hang on for 20 seconds, you'll really enjoy. So he can furnish proof under all the grounds or any of the grounds stipulated under section 2 that no principles of natural justice was followed, whatever the ground may be, as stipulated under subsection 2, even though that proof was not part of the records of arbitral tribunal. Whereas after 2019 amendment, very, very clearly it says that any party who seeks to set aside the arbitral award under section 34, then he will have to establish on the basis of the record of arbitral tribunal. So you cannot randomly in one fine misty day wake up, approach the court and produce something for the first time before the court to set aside the arbitral tribunal or to set aside the arbitral award when you very well had the opportunity to do the same before the arbitral tribunal. Because before 2019 amendment, you just need to furnish proof irrespective of the fact that the same was tendered before the arbitral tribunal or not. Now this was considered to be quite mischievous, right? As a result of which, after the 2019 amendment, they said nothing doing. You need to set aside an arbitral tribunal's award only on the basis of the proof which you have already tendered before the concerned arbitral tribunal. So I want all of you to open your barracks along with me as I speak to you. Soft copy, hard copy, I am impervious and immaterial. It's actually immaterial what you have in front of you, as long as if you have one. Anyway, so section 34, subsection 2, clause A. Now look at the grounds. Incapacity, arbitration agreement is not valid. Before 2019 amendment, the party could have furnished proof even though it was not tendered before arbitral tribunal. Whereas after 2019 amendment said, this hanky-panky business will not do good to you. You have to ensure that the pleadings are complete. You submit everything under your control before the arbitral tribunal under exceptional circumstances. Because of some compelling reason, if you are unable to submit a particular document before the arbitral tribunal proceedings, only then will I entertain it under section 34 application. But that will happen only when there are compelling reasons. Okay, that is your Alpine Housing Development Corporation versus Ashok Dhariwal, which is important purely because it beautifully dealt with this confusion created under section 34 subsection 2 clause A, pre-2019 amendment and post-2019 amendment. Now, the third case law. The third is also very important. Again, 2023 case law. NTPC सिंगर वाला वो अलग केस है आर्बिट्रेशन में, जैसे NTPC लिमिटेड वर्सेस SPML इंफ्रा लिमिटेड. Now, while dealing with this case law, I am sorry, I will have to take you through the appointment procedure under section 11. Because the moment people actually look into this particular section, which is section 11, which only deals with appointment of arbitrators, what they do is, the moment they see, my goodness, there are 14 subsections, chalo yaar, jane do. But actually section 11 is very, very easy. There is a method to the madness. You need to deconstruct. You need to be patient. You need to also have fundamentals very, very clear. And in a tabular fashion, in a tabular manner, we can be done with this entire section 11. But before we go into the tabular manner, very quickly, we'll complete what was observed in NTPC. It's a 2023 Supreme Court judgment. It held rather, under section 11, what we have already discussed, whenever an application is made before the Honorable Supreme Court or the concerned High Court, then your inquiry can only be twofold. Your inquiry can only be what fold? Twofold. Number one, existence of arbitration agreement. Number two, arbitrability of the dispute. That's it. It reiterated again so that there is no confusion. Now, there are 14 subsections in section 11, and what happens is, usually when you deal with this, we can complete this section in just 5 minutes. You can comfortably complete this section in 5 minutes. But for that to happen, you need to follow a tabular fashion. अब ध्यान से सुनना, I will fuse 14 subsections into 3 brackets or 3 divisions, beg your pardon. The first is subsection 2 read with subsection 6. The second is when there is appointment to be made of 3 arbitrators. The third situation is when the appointment is to be made in the case of 1 arbitrator. I may be crunched for space, so naturally I will be using another slide as and when I would require. So let's call this 1, second case, third case. To fruitfully use the screen, in the first case, which is what? Subsection 2 read with subsection 6. अब भैया ये तो बहुत obvious है. When it comes to appointment of arbitrators, the parties are free to decide on the nationality of the arbitrator, right? वो किसी का भी national हो सकता है. कौन? Arbitrator. Now, अब ध्यान से सुनो, subsection 2 will have to be read along with subsection 6. And subsection 2 says, देखो, when it comes to appointment of arbitrator, the parties are free to agree on the procedure. Parties are free to agree on the procedure. But whatever the procedure the parties have agreed to, if they fail, then following things will happen. So there are 3 situations. Okay. Number 1, the party, if it fails to act as per procedure, Example लेते हैं. Let us say there is an arbitration agreement. As per the procedure, within 15 days from the notice of arbitration sent by one party to the other, they had to conduct a meeting and they had to decide. One of the parties sent the notice of arbitration, दूसरा बंदा आया ही नहीं. So obviously there is failure of this particular condition. Second, when party, or for that matter 2 arbitrators, fail to reach an agreement, होता क्या है? Let us say party 1 appoints arbitrator 1, party 2 appoints arbitrator 2, and as per Arbitration and Conciliation Act, there can be arbitrators only in odd number, and both of these Arbitrator 1 and arbitrator 2 will have to then decide arbitrator 3 who will act as presiding arbitrator. Let us say this procedure is unfortunately not being complied with or the parties failed. Then third case, the person concerned or arbitral institution fails to perform the function. Then in all these cases, there will be an application. I repeat, there will have to be an application which will have to be made to an arbitral institution. Application will have to be made to an arbitral institution. Sir, कौन सा arbitral institution यार? Simple है यार. If it's international commercial arbitration, the one designated by the Supreme Court. If it's a domestic arbitration, then the one designated by the High Court. Bhaiya, why are you involving the arbitral institution to do your, to clean your dirt? You have contractually agreed upon a procedure, fulfill that procedure, appoint the arbitrator, start the arbitration, khatam kahani. Section 11, my dear friends, only comes into existence when the parties fail to appoint an arbitrator. If the parties are successful in appointing the arbitrator, then it all is hunky-dory. You don't even have to go to the doors of what or whom? Section 11. तो ये हो गया हमारा पहला. Subsection 2 read with subsection 6. Now, specifically when it comes to the appointment of 3 arbitrators, अब ध्यान से सुनना, more clarity in terms of appointment. So each party will appoint 1 arbitrator. He in turn will appoint 3rd arbitrator. This 3rd arbitrator will act as a presiding arbitrator. Now the question is, let us say within 30 days, two situations can happen. Situation number 1, these 2 arbitrators are unable to appoint 3rd arbitrator. Situation number 2, the parties concerned are unable to appoint their respective arbitrators, who then conjointly would have appointed the presiding arbitrator. In either of this situation, again the same old kahani ghar ghar ki. What is that kahani ghar ghar ki? You will again have to make an application. Are baba, to whom? Ab dhyan se sunna, there is some details. Application to whom? Application to the arbitral institution. Like for example, Mumbai International Arbitration Center or Delhi International Arbitration, so on and so forth. And this arbitral institution will be designated by the Supreme Court in the case of international commercial arbitration, in the case of High Court, which in turn will deal with domestic arbitration. अब ध्यान से सुनना, ये जो arbitral institution जो है, this has to be graded. This has to be graded by whom? Arbitral Council of India या Arbitration Council of India. It has to be graded. वहीं पे अपॉइंटमेंट हो सकता है. Now comes a very important point for your prelims. Sir, what if there is a situation wherein there is a particular high court, right? This high court does not have any graded arbitral institution within its jurisdiction. It does not have any graded arbitral institution within its jurisdiction. Then what will happen? Then section 11 says, in that case, the concerned Chief Justice of the High Court should maintain what we call as panel of arbitrators, who in turn will act as arbitral institution and facilitate parties to appoint whom? To appoint arbitrators. Khatam yaar, that's it. Now, the same procedure will also happen when there is appointment to be made of sole or solo arbitrator. Uska bhi yahi hai. Parties agree nahi kar rahe, bhago in the case of international commercial arbitration to an arbitral institution so designated by the Supreme Court. Bhago High Court to appoint an arbitrator by the concerned graded arbitral institution in the matters of domestic arbitration. High Court domestic arbitration, Supreme Court international commercial arbitration. That's it. Khatam. And of course, this particular section also has certain important stipulations as regards the time limit. Right? Kab tak tum kar sakte ho, etc. All of that. See, we have completed what looks like a monstrosity of a section in just maybe touch above 7 to 8 minutes. Maybe touch above 7 to 8 minutes. The whole of section 11. And of course, there is a time arbitral institution cannot go into yog nidra. अरे यार पार्टीज तो बोले हैं यार हम अपने काम हिसाब से काम करेंगे. No, absolutely no. Even they will have to ensure that the appointment of arbitration or beg your pardon, appointment of arbitrator is done and dusted within 30 days. So now let us go back, ladies and gentlemen. Third case law, NTPC versus SPML Infra Limited. In that limited context, I had to, on the own volition, right? On my own volition, I had to go through the rigors of section 11 because usually I find no clarity, forget about lack of clarity when it comes to section 11. Fair enough. Now, going further. The next case, my friends, ye itna, and mind you, it's a 2023 Supreme Court judgment, a curative petition. I repeat, a curative petition is filed before the Honorable Supreme Court to reconsider this particular observation. Itna zyada current affairs mein hai ye. If you are not aware of this 2023 Supreme Court judgment, then I am sorry, you are living in Mars or perhaps any other outer planets of our solar system. Why? Because every single newspaper worth its salt, every single legal news column worth its content has dealt with this particular important case law, very, very important case law. It's a constitutional bench judgment, 2023 का case law है, NN Global Mercantile, NN Global Mercantile Private Limited versus Indo Unique Flame Limited. It's a constitutional bench judgment. 3:2 अर्थात 3 majority पे है, 2 minority है. What is it that the Honorable Supreme Court has observed which has led to this very interesting circumstance of eventually a curative petition landing before the doorsteps of Honorable Supreme Court? Now ध्यान से सुनना. There is a contract. As per Indian Contract Act, this particular contract had to be duly stamped. Let us say the contract is not stamped and this contract has an arbitration agreement clause. The issue is the moment the contract which has to be mandatorily stamped remains unstamped. Obviously stamp duty sarkar ko nahi milega, there is a fiscal loss. In that case, can the arbitration agreement clause in that unstamped contract survive or not? Can it survive or not? Now, come back to the board. 2021, there was what we can call NN Global 1. NN Global first case, this was in 2021, and NN Global 2, this is 2023. In NN Global case 1, which is 2021, the observation of the Supreme Court was very clear. Arbitration agreement can be severed from the main contract, and even though the contract stands negated purely because of the fact that it remains unstamped, it almost is in the limbo, having no legal teeth whatsoever because it remains unstamped. But arbitration agreement survives, to which NN Global Mercantile Private Limited versus Indo Unique Flame Limited said no, no, no. 3:2 constitutional bench judgment, the majority said even the arbitration agreement which is part of the unstamped contract stands cancelled, it is lifeless. So, लोग डर गए भैया, all the contract which had to be mandatorily stamped, अब भैया stamp नहीं हुआ है, then you obviously have disputes. Then as per this case law, the arbitration agreement can effectively go for a jog. It remains in limbo. Massive, massive impact. Massive, I repeat, massive, massive earth-shattering impact. That is precisely the reason why there is a curative petition on this particular issue. Let us see what will be held by the Honorable Supreme Court. In the meantime, I hope you are attuned to the facts mentioned by me, to the legal developments mentioned by me pertaining to the unstamped contract and its impact on the consequent arbitration agreement clause. If the answer is yes, then do please punch in, if at all, if you are interested to maybe exercise your fingers in live chat. Please do exercise your fingers and please do tell me as to whether this point is clear, because I repeat, this is very, very important. From the MCQ's perspective also, they might perhaps, DJS can trouble you with this. कि भैया unstamped contract, उसमें क्या होगा फिर arbitration agreement का. Anyways, I think you guys, थोड़ा बहुत procrastination, some amount of procrastination is fine, cool, no issues at all. But I presume, even though it is a rebuttable presumption, that the same is now well understood by you when it comes to unstamped contract. ठीक है, आखिरी के दो cases and then we are done, right? The fifth case, again pertaining to 2023, Larsen Air Conditioning and Refrigeration versus Union of India. It's a 2023, just to highlight once again. Very, very simple observation, very, very clear observation by the Honorable Supreme Court. The Supreme Court said the court under Section 34 cannot modify the arbitral award. It can only set aside. It can only set aside. It cannot modify. So another 2 minutes, we are done. Unless and until you have some questions. So the concerned person may perhaps look into the streaming bit. Anyways, the last case law, and then of course you can ask questions pertaining to case laws, of course. Yashdeep Builders versus Sushil Kumar Singh. This is the Delhi High Court judgment, 2023. All these 6 judgments are of 2023. उनको बुलाइए, आशुतोष को यार. Delhi High Court 2023. What is it that was observed? The scope of Section 9. What is Section 9? The power of the court to grant interim measures. The scope of Section 9 does not contemplate restoration of contract. Restoration of contract if the contract is terminated. It's very clear. Very, very clear. Under section 9, this is exceptionally clear that whenever an interim measure application is filed before whom? Is filed before the concerned court. Then in that case, my friends, under no stretch of imagination, if the contract itself is terminated, no court can restore it when an application is made under section 9. The court's business is to only do what? Interim measures. Just like, don't forget this particular, 1-2 minute and then band kar dijiye. The court's business under section 34, what was the business? Set aside the award. Don't try to modify the award. In the same breath, grant interim measures if so required, but under no circumstance you restore and resuscitate the contract if the same contract stands terminated. That, I'm sorry, you have no business to. I'm sorry, you have no business to, right? All right then. I think काफी हो गया यार केस लॉस 6 2023 का and then 7 before. I think this is more than enough. Are there many other case laws? Of course. In Arbitration and Conciliation Act 1996, you can have 50 plus case laws which are exceptionally important. But from the examinations perspective, DJS obviously looks into those case laws which are phenomenally important from the current affairs perspective as well. And as you are aware by now, especially the case law pertaining to the unstamped contract and its impact upon the arbitration clause. That is very, very important, along with, of course, all the other case laws so discussed in today's very, very short, brisk, but I presume fruitful class pertaining to case laws. If you do not have any doubts on the case laws, then we will all collectively escape velocity. Right? We can escape velocity by greeting each other. Best wishes for your exams. You don't have to greet on the screen. You can greet wherever you are. That would do. All right, so that's a very short, crisp class on case laws. All the best, guys. Thank you. Thank you.